All right. Well, yes, this is joint work with Oscar Kouwenberg, who some of you may have seen. I've done many papers with him in the past. He's from the University of Groningen in the Netherlands, and I guess you're going to start, and then I will take over. So when you give it a shot, and I'll play slide keeper too.
Okay, well, I would like you. So thank you very much for the opportunity to be here. Bringing in the international angle towards the symposium from the Netherlands, a very small country in Europe, of course. So I like to be here.
Good lawyers.
Good lawyers. So I'm very much honored to be here on the panel as well, discussing specifics about what is it, American Bankruptcy Law, Chapter 11, which is, for us in the Netherlands, I think is still something that we look to as a kind of inspiration, trying to better our bankruptcy rules as well, but with a different twist though. But we might come back to that later. But for the moment, I think we are better off focusing on our paper here today, looking at these private benefits in bankruptcy cases. So I'd like to take you along a route on. First, a bit of an issue on where control resides, then a bit about how to, and we can see private benefits. Then Stephen will take over for 3 cases that we've been looking into for this paper, and hope we can take stock. And in the end, we hope that the panel as well as the audience can help us bringing this draft, because it's still a draft, further in tying in to bring in control aspects into bankruptcy in a better way even than we already try to do today. So that's it. So let's start with the control aspect. I think as we are looking at this, and I hope it will flip. No, this is the one. Yeah, we're trying to synchronize my slides here over here with the one on the back. What probably is not very new to you.
Oscar, if you want to sit here, you can see.
No, I got them up here, but the only issue for us is to synchronize our slides that we are.
So it's just whether his co-author is smart enough to follow along on the tablet. So.
I was presuming he was.
Yeah. Risky assumptions.
Okay, it's really the control thing. I think it's a double-edged sword in the sense that you need control for in a company to enhance its value, to maximize its value. Of course, otherwise you won't be doing anything. But on the other hand, it also gives you the option to extract value for your own or in private. So these are these private benefits, which might, in one sense, hamper then the development of the company or hamper financing options for the company. So I think that's very normal. That in the discussion in control situations in firms. So how then does Chapter 11 enter in? I think we put it down here in red. It complicates things, but it does not diminish the scope for vying for private benefits. And I think that's one of the interesting part of the cases that we're going to discuss just in a couple of minutes that you can see that. So. Let's do the next slide. I'd like to, from a bit of a theory perspective, I think it's important to note that if we're looking at the issue where control resides, you're actually talking about a double control shift. The first shift is that in bankruptcy you see it shifting from shareholders to creditors. But at the same time, but it actually is separate from that, is a shift from creditors to a federal court. Or in other cases, in other bankruptcy systems, it's not necessarily the court what you're looking at, but you're looking at the trustee who is taking over the management of the company, which is, for example, is the case in the Netherlands, where a trustee intervenes into the setting and assumes control of the corporation. So that's a double control shift. You see a shift from shareholders to creditors, and you see a shift from creditors to a court-imposed form of control. So that's one part. The other part is that if you look at the control setting, we identify a kind of a typology or a matrix where I think it's important to see where control resides, and that's on one axis is the controlling shareholder situation versus board control. So no controlling shareholder. On the other side, on the horizontal axis, you see the whether there's a controlling creditor group or when there are dispersed creditors. And then you can see four items. You see the situation where there is a controlling shareholder and a controlling creditor. You see probably a situation which you can call it a contested plan, or where controlling shareholders and a coalition team up together, and it's a coalition-led plan then that is going to be affected. When there's dispersed creditors, you probably see something of a plan that is shareholder dominated by the controlling shareholder then, to be sure. And if you look at board control and a controlling credit group, it might be very well the case, or very easy to understand, is that creditors will be dominating here the plan, while if there is board control and there's a situation of dispersed creditors, we see a board-dominated plan. These are actually kind of extreme forms. It's more difficult than that because situations change rapidly. For instance, the situation of dispersed creditors can easily change into something of a coalition-led movement of creditors when hedge funds or others are trying to buy up claims in the market. So then you end up in a controlling creditor group. But it's also not the end of the whole story, because also in a controlling creditor group or in a group with multiple controlling creditors, the situation may be that they end up with one plan of all of them together, or they may vie for control in such a sense that it ends up in Chapter 7, for instance, because they cannot come to any solution at all. And also in very complex cases, it might be very difficult to strike a plan, which also may end up something else than in Chapter 11. So actually this is a nice topology to think of things, but it's the beginning to see where control might become a problem. Next, having said that, I think it's then necessary to start over to the private benefits part. And if you look at control situations, it's interesting to see what kind of forms you see there in private benefits. You see compensation schemes, especially with respect to managers. But also asset tunneling is an important part with where private benefits are enjoyed. And also something like control happiness is an issue here, for which the party in control actually derives benefit from being in control. These same things might be also witnessed in Chapter 11, but it adds a couple of interesting elements to the whole plan thing, and that's you get a veto power in Chapter 11, so there are parties or participants able to veto any plan, of course, or they have the ability to force acceptance in the plan, as what also Ted was already discussing this in the beginning of the symposium. What we then may see is that these private benefits do take more or less the same forms, but they differ a bit. We see side payments in Chapter 11 cases, either to obstruct either veto power or force plan acceptance, or allocation of undervalued derivative securities or securities in general, spraying of fees over all kind of participants. And I think that's an important part to know, that we are talking about private benefits here in this situation of a Chapter 11 case. And I think this is the moment that I give over to my co-author here.
Right, so
interesting cases.
To understand this, we examined 3 recent cases in some detail to try to understand what exactly is going on. I guess the common theme among the 3 cases, which is true, as was mentioned earlier today, of many recent bankruptcy cases, is they're all in the broad energy industry, although one is coal and 2 are oil and gas. So we have first the Peabody case, where basically the plan is being funded by the sale of $1.5 billion of new equity that is split equally between common and preferred. The preferred is particularly interesting, basically because it is being it has all the rights of equity of the common shares, and then extra benefits as well. And it is also being allocated, 23% of that is being set aside for a group of early plan supporters, bondholders. I'm not sure they were in a formal ad hoc committee, but it's basically a bondholder group. The supporter bondholders, in addition, got $120 million of cash, $35 million, a little over $35 million per month from basically confirmation until effective date, warrants for some more common stock, and the inevitable professional fees paid. Why did they do this? Well, they agreed to support this plan and reject all others. The documents in the case almost protest too much. They make it very clear that the bondholders who are getting all this stuff are getting so because they have agreed to backstop the new preferred stock and not because of their status as bondholders. So you perish the thought that they are receiving this because of their status as bondholders. Our next case is Seadrill. Now, Seadrill is actually still in flux because there's just yesterday or the day before there was an announcement that a new plan had been agreed to, but we don't know the full details of that plan, so something that Oscar and I will have to deal with when we finalize the draft. But the original plan was proposed by a controlling shareholder and Centerbridge, who held about 10% of the unsecured bonds. And then Centerbridge ultimately brought in a couple more funds into the process. The plan supporters committed to basically backstop the issuance of $860 million in new secured notes, as well as $200 million in new equity. I note there that interesting in this case is that at the first day hearing, Seadrill said we don't need a dip because we've got so much cash, which then of course raises the question about why they need this new financing, but all right, so we have that. The new notes, 7-year term, they have a fairly complicated interest rate structure, 8% in kind and 4% in cash. The new notes, the holders of new notes will be entitled to basically not quite 60% of the new equity. Eligible unsecured creditors, basically qualifying institutional investors who agree to support the plan, can buy up to 10% of the notes, but all the remaining notes are earmarked for the original plan supporters, basically the controlling shareholder and Centerbridge and friends. Plan supporters also get backstop fees, closing fees, right to buy up to 25% more of the equity, which comes with an equity purchaser fee as well, an additional 5.5%, I've got double decimal points there, of common equity as a structuring fee, and of course their professional fees paid. Now, our third and final case study is actually not a Chapter 11 case, and it is a Chapter 15 case in the United States presided over by Judge Glenn, and a French proceeding. I can't do two things at once. And so here we have an ad hoc committee of senior note holders bound by a lockup agreement, which is governed by French law, which probably keeps Judge Glenn from looking into the lockup agreement too much because it's going to be enforced by a French court and not by an American court. It includes a right to specific performance in France of the lockup agreement. Plan includes $375 million of new second lien notes combined with penny warrants to the eligible senior note holders, backstopped by the ad hoc committee. Eligible senior note holders permitted to subscribe to new debt if they sign the lockup agreement. So basically agree to the plan and you can get in on the new securities. Warrants gave the new note holders right to buy 16% of the reorganized equity. Notes also receive a cash coupon of at least 5%. It's a floating interest rate with a floor of 5%, and also an 8.5% coupon. Again, a fairly complicated structure, which, as I'll talk about a little bit more later, this kind of ties back into my question to Don earlier about as you start to distribute more and more complicated securities, do we really know what people are getting in some of these plans? The ad hoc committee gets a 7% commitment fee, a 3% backstop fee, warrants for 1.5% of the reorganized equity, warrants for a further 1% as a global coordination fee. The names of the fees are, I guess, potentially unlimited, so if you can think of a name, you can call it a fee as well. And then, of course, they get their professional fees paid as well. So then we try to sort of take stock and think about, all right, if this is the, the new state of the world, and again, it's not just a Chapter 11 picture, but it is also a Chapter, 15 picture. You essentially, right, when push comes to shove here, you have to note that, right, we have asymmetric treatment of creditors in the same class. Some note holders, the ones who are in the inside group, get all these various fees and their professional fees paid for, allegedly not on account of their claims, but nonetheless, right, certain bondholders are getting more recovery than other bondholders when the dust settles on these Chapter 11 or Chapter 15 cases. Minority stakeholders face freeze-outs or possible coercion, and we talk about this in the paper. Coercion in the sense that if you think this plan is going to go through, you have some incentive to sign the lockup and agree to the plan, even if you don't think it's the best plan ever, because you don't want to give up on that extra recovery that everyone else is getting. So, in this sense, it's like the two-tiered coercive tender offers of the 1980s in Delaware, where there's just, even if you don't think this is the great deal, you're going to sign up to it because basically you don't trust your fellow bondholders not to sign up to the deal because they're the ones who proposed it in the first place. There's potential, at least, for coalition-led expropriation. We don't really know. Right, it's hard to tell what is going on in these cases, especially from an outside perspective, as we have. But it is certainly possible that coalitions are forming here in ways that are dividing up the value that certainly wouldn't necessarily correspond with what we would expect. And then you have to wonder if some of this isn't just intentional complexity in the plan distributions designed mostly to make it difficult for anybody to figure out what is being distributed, especially when you have, debt instruments that are paying coupons where you can't really tell what the coupon is going to be, right? And you also have the additional thing that I alluded to in Seadrill. And I think we kind of get to this in the conclusions, so maybe we'll jump there. Right, and so maybe let me take a step back. First of all, right, debtors in these cases don't seem to be focused on necessarily maximizing value. If you wanted to maximize value, presumably you would all this new financing would be open to everybody, and you would want to get it on the lowest price possible. Instead, in many of these cases, the ad hoc bondholder groups are very insistent that nobody else can provide this financing except for them. So you're not trying to auction this for the cheapest price possible. Chapter 11 is being used to achieve ends that you could not achieve under state corporate law, in part because, and this goes to the next bullet point, in the 1980s, the Delaware Supreme Court had to address a lot of these issues, and they came up with various fiduciary duties like Unical and Revlon to address a lot of these issues. We don't have any of those things in Chapter 11/Chapter 15. Also, as Oscar and I say in the paper, it's not clear that a fiduciary duty like that would work in Chapter 11 or Chapter 15 because because Delaware, in some senses, had it easy, right? Because you basically, and this refers back to the first panel as well, right? You're only talking about shareholders, where it's the whole capital structure. And Chapter 11, who is entitled to enforce the fiduciary duty is very unclear in that situation. But basically, right, there is, and I guess, our last point before I make that point, right, is this sort of, the bankruptcy preference for consensual deals and swift resolution is working against probing examination of these deals with ad hoc committees and, restructuring support agreements and lockups. So the way Chapter 11 and bankruptcy is supposed to work is in tension with kind of us really figuring out what's going on in a lot of these cases. And that leads to a very unclear situation. I don't know if you want to add some more before I ramble any more about conclusions or things like that.
The fine print, I think, is important here. Is that when we're looking at control transactions in general and focusing on shareholders, that situation in Chapter 11 also occurs. Only it's much more difficult because you're talking about multiple stakeholders, multiple preferences, and multiple incentives. And it does not easily translate towards a situation, but you see the same problems cropping up. So how to help this out, that's really difficult. Yeah.
So to transition, we actually talked about this somewhat last night. right, the extent to which the shareholder fiduciary duties under state law work fine when you're worried about shareholders. Yeah. Once you're talking about other interests, you suddenly have multiple solutions that have distributional effects across the capital structure, and the problem is that state law fiduciary duty does no work whatsoever, and then a question is to what extent is bankruptcy able to do that kind of work. I love the fact that I didn't tell anybody what to write about except for the broad topics. Yeah. And I didn't even expect that one of the panels would go international and the papers would fit so nicely together. But
Can I ask a clarifying question before we start, Jake?
Yeah, hold on. Let me finish my ramble here, which is that this problem isn't just a U.S. problem; it's also a global problem. Yeah.
Can I? Those three cases you did, where do they fit on your typology?
So,
which cell do they go in the matrix?
You can save that for later, John.
No, it's the Frederickson case.
Cedral.
Cedral is in the contested plans for the controlling shareholder, controlling creditor group. That's the Cedral case. And the other two are.
Yeah, right. You left me in charge of the remote.
Yeah, that's the board control and the credit groups. That's the other one. The other two are in the lower left.
Okay.
So we don't see the thing here with dispersed creditors that much. I think that's
and I
not
guess
so much an issue at the moment.
Yeah, one last thing I'll say before we let Jay talk too is Cedral is interesting because it's the only one where the bondholders, the objecting bondholders, actually seem to have gotten their act together to call a halt to the process. And so I think, in our next draft of the paper, we need to talk about why Cedral is different, because it does seem that the initial plan that was trying to be forced upon them is not going to be the final plan in that case.
What I think is also important to note in these three cases is we're not talking about issues of secured creditors or senior creditors, but all kinds of types of creditors are associated with the fighting over the spoils of the whole thing.
Okay. Oh, all right. I will cede control.
Okay, so the question, which maybe we can talk about later, is if you view the Jevic, Supreme Court's decision in the Jevic case as really not being so much about structured dismissals as being about fidelity to the absolute priority rule and when you can depart from it, isn't that really the question that you're raising? And whether these departures that you're observing from the absolute priority rule based on new financing or based on, pre-plan agreements or whatever it is, whether those in fact are permissible departures.
Whether they're permissible and the unanswered question in Jevic and for that matter by the modern Supreme Court about, like, for example, does the new value exception still live and things like that, right?
Wait, stop.
Okay, yeah.
We need to leave time for Dennis and Jim, so Jay.
Yeah, and I'll make it short, particularly because many of you will say, what is the relevance of your paper to the overall theme here? And that's a legitimate question, which I don't propose to answer. Ted convinced me that my paper was somehow relevant to the overall subject, and so I leave it to Ted to defend that after I finish. There is at least a connection, perhaps, that it has to do with information and transparency, which is what a great deal of our discussion last night and again today has been about. My focus is on insolvency, the circumstance of insolvency, and in particular insolvency proceedings. And as Henry indicated earlier, he and I have put forward the idea that there really are two systems of governance here, the corporate governance system and the bankruptcy governance system, and that it is important to invoke, realizing how difficult it is to define this, it is important to invoke the bankruptcy governance system when there is a sufficiently serious level of financial difficulty. Okay, what I want to talk about are corporate groups and disclosure with regard to corporate groups. That's one reason this has some international impact. And I have two central ideas in this little paper that I've given you all. They are, number one, our treatment of corporate groups should learn from secured credit. and the systems that we use in the United States and increasingly around the world with regard to the very important claims that a secured creditor has against the assets of the company. And our rule is that there has to be disclosure. It's relatively simple disclosure under Article 9. It's a sort of blunt, simple, you better find out more from the interested parties disclosure, but it identifies a really important set of claims against the company's assets. I want to argue that we should apply the same rule with regard to the partitioning of assets, which is increasingly used, especially internationally, as a device instead of secured credit or as a supplement to secured credit, because we don't have a universal system of secured credit, and therefore partitioning of assets, putting the assets in a particular pool to which only some creditors and other claimants have access, is increasingly a device that is used domestically as well, but particularly internationally. And my second key idea is about honoring the corporate form. And the key idea that I want to put forward there is that we should honor the corporate form throughout the life of the corporation, and specifically throughout the life of the affiliates in a corporate group. That is to say, we should not have so much of the current situation in which the corporate group is run as a single entity most of the time, and then ultimately, when it comes time for bankruptcy, or even just serious financial distress, all of a sudden the affiliates, we've got to honor this wonderful structure that was established by some lawyer 30 years ago, and that certain creditors may or may not have been able to take advantage of in the meantime, and as to which there has been almost always really lousy disclosure, really very little disclosure, even in public companies, much less in private ones. Now, I'm not trying to propose a new system. I want to emphasize that. What I am, however, is throwing out a proposal for thinking about a new system with respect to disclosure in corporate groups. There are two types of abuse of the corporate form, that is, abuse where it is not honored through most of the life of the corporate group and then suddenly emerges from the lawyer's briefcases when there's financial difficulty. And there are two principal types, I think, at least that I want to talk about today. One of them is disregard of the corporate form throughout most of the life of the corporate group, and the other is actual manipulation of the corporate form in the context of financial difficulty. And at the time, or close to the time, the financial difficulty becomes apparent, at least to the management of the company. There are many examples, I'm sorry to say, of this sort of thing going on. I'm going to talk very briefly about two of them. One is the Nortel case, which many of you may know, but others may not. It was a Canadian company. It was actually the successor to Canada AT&T, and it was a high-tech company with subsidiaries and operations all over the world, very much involved in network connections and that sort of thing. Unfortunately ran into financial headwinds, filed for the equivalent of Chapter 11 in 3 countries, in Canada, in the United States, and the United Kingdom, although it had operations in many other and assets in many other countries as well. As it finally played out, it was really the Canadian and the U.S. proceedings that mattered in resolving the case. And the problem is that the problem that was presented in Nortel is that the intellectual property of the company had never been properly allocated as between the corporate parent and a variety of subsidiaries. So that literally management had misplaced what turned out to be $7 billion worth of assets. It was not possible. 2 courts found, a Canadian court and a U.S. court, found after an extraordinary amount of litigation that these assets could not be placed accurately and fairly in any one of the corporate affiliates or even in the parent. And as a result, they had to come up with a rather awkward solution to come as close to fairness and accuracy as possible in that case, a solution that it would have been, I think, impossible to anticipate in advance. So here you have a situation, and there was endless testimony about this, that the Nortel was run as a single company, that management did nothing that reflected the separate existence of these various affiliates. If research and development took place here, but it also took place there, and resources were allocated over there, and all of them were distributed and used throughout the company without regard to either geographic or corporate boundaries. And then all of a sudden, of course, when insolvency was filed, it became terribly relevant who was the owner of these assets. The bottom line in Nortel is that the parties spent, are you ready for this, $2 billion, yes, that's a B, $2 billion litigating the ownership of these assets.
We should be happy about that.
Join the lawyers. Brotherhood.
Absolutely. My paper is about doing great things for transactional lawyers and giving them a lot more business and much less business for litigators. That's exactly what my paper is about. And what's important to understand here is that there was also good news in Nortel, and it makes very much the point that I want to make. The good news in Nortel was that at the start of the case, when people realized that all this was very unclear, they agreed consensually among the major creditors to sell the intellectual property worldwide without regard to geographic or corporate boundaries, right? And as a result, they got far more for the intellectual property than anyone thought they would. It's a sort of one of Don's stories. $7 billion was far more than anybody thought they would get because they sold it as a piece, right? As if it were a corporate asset. Then they spent $2 billion arguing over who was going to get the $7 billion, which is, of course, outrageous and should be disgusting to all of us, regardless of self-interest. And I was an expert in the case, so I'm as self-interested as anybody. But in fact, that was a terrible and shocking amount of money to spend because of the corporate misplacing of the assets. So from that, I want to argue very strongly that all of this was about honoring the corporate form. Which of these affiliates within the corporate group was really the owner of these assets, and therefore its creditors would benefit disproportionately from the money that had been obtained. $2 billion later, and a televised trial, by the way, if you didn't know this, a televised trial that was held simultaneously in Toronto and Wilmington, with evidence being offered in either case to be applied in both cases, 2 opinions issued under the separate laws of the 2 countries, but with a common result, thank God, with respect to the major distributional questions. All right, so that's the first one. That's disregard. Throughout the entire life of this company, those affiliate structures didn't matter, except, well, for taxes and their transfer pricing and other totally, different sorts of purposes, but they didn't matter for ownership. And both courts found that it was not possible to accurately allocate, after $2 billion worth of expenditure, to allocate who owned this property. All right. Second example, Caesars Casinos. And this is my example of manipulation. Now, I hasten to say I'm not talking about intent. I'm not saying anybody defrauded anybody. I don't know the case well enough to say anything about that. So please don't misunderstand me. But having said that, there was an examiner's report in Caesars, and that report found, there's a wonderful start to that report. I wish all examiners' reports were like this. It starts off saying, the question is, were assets allocated in ways that cause losses to creditors? The answer is yes. That's the first 2 paragraphs of the examiner's report, which I think should be an example for all of us. But the examiner goes on to find that over a number of years, 6 or 7 years, there were a host of movements of assets and liabilities around within the corporate group. They were not disclosed. I mean, maybe they were disclosed under SEC rules, but they clearly were not understood by lots of people in the market. And as the result of that was to very seriously narrow the rights of creditors to the main operating company, which is undoubtedly the company that most people in the market would have thought of as being Caesars. So the consequence of that was this enormous examiner's report, also very expensive, by the way, and finally a negotiated deal as a result of that report. Lots of litigation, lots of delay, and inevitably in any settlement situation, very unlikely to be ultimately fair to everybody concerned because settlements don't work that way. So the pitch that I want to make is that we should require, if we're going to honor the corporate form in insolvency, that we should require that it's been honored throughout the life of the company, or at least for a substantial period of time before it entered financial distress, that public filings be made with respect to those affiliates that are separately treated, including financial information, at least basic financial information. And the rule I would put forward would apply to private companies as well as public companies if they don't want the corporate group to be treated as a unity. So the presumption or the initial position would be the corporate creditors as a group are entitled to the proceeds of the corporate assets, assuming insolvency. And that anyone who wants to make the claim that, well, I'm a creditor of a separate affiliate and I should be treated differently, which might be a plausible and reasonable claim, would have to make that case in an insolvency proceeding. The idea, of course, is to try to impose a discipline on corporate lawyers and even more on corporate management to pay attention to their corporate lawyers and run their corporate groups in a way that is fair and transparent with regard to the separate corporate existence. And I'll just finish by saying this. All this will seem to at least some people as fairly radical, but it really turns on a very simple proposition, which is limited liability. That's an extraordinary gift that our law gives to the corporate form, the opportunity to deploy capital with only that capital being at risk, but also the opportunity to divide up assets, to partition, in the currently popular phrase, to partition the assets of the company in ways that are not necessarily obvious to those dealing with the company, and to run the corporate group by terms of brands, in terms of logos, in terms of everything designed, it would almost seem, to mislead everybody who deals with the corporate group as to where the assets really are and with what affiliate they're actually dealing. So I think we should change that. I think we'll have to do a lot of thinking about it in order to develop a good system to do that. It may be something that I'll suggest to the ALI as a possible thing, or perhaps even UNCITRAL, although UNCITRAL would be very tough because they're all so conservative about any sort of a new legal initiative. Anyhow, that's my idea, and Ted will explain why it's relevant to this conversation.
I don't think I have to. I think it fit quite nicely. So, Dennis.
What would you like me to do? I am neither a bankruptcy lawyer nor did I have the opportunity to read any of the papers of any of the presenters thus far in this panel. Having said that, never at a loss for words. Control is a concept I'm very familiar with in a solvent company situation. There's a great article I would refer you all to if you're interested in the concept of control. It's by the late Al Summer, Control, Who's Got Control is the title of it. And his point is still relevant today. It was written many years ago. Control in the solvent company sense is you have 51% of the tickets, or you have contractual rights that give you either actual positive control or negative control or blocking position. And Ted, of course, I did read your piece and was prepared to comment on your piece, which I sort of will do as I try to comment on a whole bunch of things I don't really understand. Not easy to do. To begin with, my favorite American philosopher, Mel Brooks, once said, "It's good to be the king." And when you translate that into what we're talking about, control in the form of any enterprise that's owned by a diverse aggregate group of people is going to have some aspects of people with more influence than other people, maybe not control, but influence. And in the non-insolvency circumstance, we deal with that through disclosure. If you're a 5% non-passive investor, you file a Schedule 13D. If you're a 5% plus passive investor, you'll file a 13G. It's an innocuous document that is misused more than it's properly used. But a 13D will tell you in item 4 what the so-called 5% holders' intents and plans are. And that's very easy to do, pain in the neck, but relatively easy to do. You're passive, but you're thinking about things you might do until the next day when you announce some of the things you're about to do. You lay out what your interest in the company is, and you indeed talk about, for the most part, how you accumulated your shares, at least in recent times. You talk about any contracts you have with third parties that might give you certain rights that others might not have. Ted, in your piece, you talk about what you viewed as the empty creditor problem, and you talk in that regard. I'm sorry?
It's Henry's idea.
But you discuss it.
But I discussed it.
You've lost your interest in it.
I gave up control.
And you talk about the problems of dividing, in essence, governance and equity, or governance and value, or vote and value. And as I say, that's not an unusual thing. CBS has that, Viacom has that, many companies have dual ownership of stock, where there's a control person, and that control person is permitted through his control or its control to make determinations which may not be in the best interest of all of the shareholders. And indeed, we have lots of litigation. Many of it I did back in the 80s, and we have doctrines which are not duties, but are standards of review, whether it's Revlon or Unical or Blasius or entire fairness. Indeed, even the business judgment rule is a standard of review as opposed to a duty or an obligation. And in that regard, we look at misuse of control and we correct it. So you have disclosure and you have a vehicle for dealing with it. I don't see much difference in bankruptcy other than you really can't have the equivalent of a 13D. You can't make the participants in a restructuring describe in some document that's going to have a living effect to it. It's going to be dynamic. It's going to go on. What their strategies are or what their trading is, because what you will do if you go to that regime is to destroy what is good in bankruptcy, and I'm one who doesn't see much good in bankruptcy, but what is good in bankruptcy, which is people have liquidity. Liquidity is essential to a regime, a capital markets regime, and trading in bankruptcy stocks gives you that liquidity. So if you're going to take out of that marketplace a large number of potential buyers and sellers, you're going to leave those with shares in a bankrupt company, which probably would tend to be nothing more than the retail owners of the former corporate entity, with a stock that's going to have no trading, no liquidity, and not be a good thing for the market. So again, I don't think you really can have a regime making people who are trading in different forms of equity, whether it's a credit swap, it's a vote-only piece of paper. You're just going to hurt liquidity, which I think will hurt investors. So unless there's something else someone might want to ask me from a corporate standpoint, I'm going to defer to a more knowledgeable corporate lawyer on my left, Professor Fanto.
That's a big exaggeration. What? Oh, I'm sorry. Okay, so, well, that's an exaggeration from the person who wrote the book on the business judgment rule. Okay, well, I'd like to give a few comments on the two papers. And again, but apologize, you know, you're getting comments from someone who does corporate and securities law and did bankruptcy some 30 years ago in practice, and I don't remember anything really from that time. So as for the first paper, the Lubin and Ellenberg, excuse me if I mess up your name, as you know, and as they presented, they're pointing out how controlling shareholders, and for the most part boards, depending upon the circumstances, obtain private benefits and other control rights in control transactions that occur in Chapter 11. And I think, what's interesting for a non-bankruptcy person is the sheer complexity of the circumstances, the fact that you have blocking positions given to multiple creditors, which then magnifies the number of parties who can promote their own position and obtain special benefits and rights, in contrast to the corporate situation outside of bankruptcy, where you don't see, you see opportunism, but not in such complexity with such permutations. And I think that adds to your kind of analytical difficulty. Now, My first general comment, again, from an outsider's point of view, is like, well, why do we even care about these circumstances at all? And it seems that you care if there are parties here who are structurally disadvantaged by the existing state of affairs. But I mean, you do say at one point in your paper that, look, a lot of parties in Chapter 11, and to use your words, you say they can hold their own. So then I was left wondering, well, if they can hold their own, why do we even care about this? So maybe there's something, maybe it's obvious to you in bankruptcy, well, we should talk about them, they're trade creditors or whatever, who can hold their own. But, why couldn't they have cashed out before they even get to the bankruptcy situation? Or are there just people structurally who can't, that we should care about here? Because really, in normal control situations outside bankruptcy, I think the courts presume, well, there's an exit path in the market, and although that doesn't justify the courts not looking at the circumstance, it is one that gives them some comfort. Well, people can leave. They can get out of the capital structure. Now, my second set of comments is, it might be worthwhile to discuss your examples in a little bit more detail. Again, maybe it's clear always to you. I mean, from my point of view, I kept wondering, well, what was so inequitable here? Well, there are a lot of fees, and as you point out, it's hard to keep track of everything. But again, it's contrasted with certain debt holders throwing their support behind plans, providing new financing, and so I thought, well, what's the problem there? And then in the second example, the Heman and the funds example, you see the same thing, putting new money in or putting their support, and they even have a 3-month go shop structure where you say, okay, well, they said, okay, is there something better? Is there another plan? So I think it would be a little bit more convincing, or maybe not for the insiders of, who are around the table, so it's obvious, but maybe for the outsiders, it would be a little more convincing where you say, to just show, well, who is being harmed here, and why what these people are doing is improper. And I think you could say that in the third case as well. You make a comment, well, the senior note holders are taking precedence over the convertible holders, and you go, so? I mean, there are ones lower down, so it wasn't obvious. An additional comment is, then I was just crying for a solution. I said, okay, you've laid this out, and there's improper taking of private benefits, tunneling. Well, okay, what's the answer here? And now maybe that there's no ready answer for you, but then I started thinking, and we'll offer a few thoughts here, but which you probably have already discarded, and it sounds as if, like last night, you discarded them too, so kind of questions the value of why Ted even asked me to comment, because I'm looking at it from outside the bankruptcy situation, and I really, I just kept thinking about this and saying, well, what could I possibly tell them? Because I'll say something, and then they'll say, well, no, that doesn't work in bankruptcy, and this doesn't work, and I mean, you know that the Delaware courts, and certainly, Henry and Jay have talked about this. What they do is maybe not satisfactory, but the only thing I could come up with was, is there any, the Delaware courts, particularly with respect to controlling parties, the parties who are most at issue with taking private benefits in particular transactions, often in a shift of control, they'll do their most to try to have the controlling party disable itself. So I just I mean, I kind of throw that out. You know, you see it in Con v. M&F worldwide where the courts say, okay, the controlling party, you're involved in a sale of control, but you have to disable yourself from both the negotiation and the voting. Now, maybe, so in a kind of simple-minded way, I was thinking, well, can you do anything like that in bankruptcy? But maybe that runs up against the sheer complexity of bankruptcy. Is like, well, whom do you disable? There are so many parties to disable that it won't really work. But I don't know, maybe you could address that if you see fit. Is there any way, does the judge have power to do it? Since in the Delaware context, the courts will step in, but they'd rather have the parties work this out for themselves. This frankly is the same approach that's taken in the management buyout situation in Delaware as well. I mean, not really a situation that we've, it was in the, in the jurisprudence years ago, and it's not so much today, but comes up now and then. But in the management buyout context, you have the CEO who's kind of the favored party in the control shift, and, you have multiple bidders with the CEO having that inside information. And I think that, it's a Revlon circumstance, but I think the courts have tried to fashion remedies that I think go to this disabling concept. Well, can we somehow disable that favored position of the CEO in a MBO? And they'll do it in very granular ways. I mean, it's always not one solution. They may say, oh, the CEO's too much involved here, but this other circumstance and the voting cured it. So it's just a thought that I throw out to you that you can address whether it could work or not in these circumstances. Let's see. Okay, I think that's my comments for your paper. I apologize for the Westbrook paper because I really just got it yesterday and then had to read it on the train.
Entirely my fault.
And so I'm not, didn't think as much about it as it deserves. The only initial thought is it certainly strikes true to home. I mean, I work in the financial services area, and anybody who's done any work with, the SIFIs or the large financial groups knows, well, okay, if you take a look at their corporate structure, it's just Byzantine in complexity, and even in those circumstances, we at least have regulators who are allegedly overseeing these large financial groups. And we even today have the requirement of living wills, which at least tries to have those groups explain, well, what happens if things go down, even though that focus is really more on the protection of, prudential protection of the financial system than it is on individual creditors. But maybe more specifically for your paper, you raise the issue of, well, who might do this as a group? Is that, it could happen almost, I guess, through negligence, or it could happen through intentionally. So as you say, it's like inadvertent confusion about the group or intentional manipulation of the corporate structure. So the question is, or maybe you want to talk about it, is that a distinction worthwhile making in your solution? I mean, we do it in the piercing the corporate veil area where, you always combine relief with respect to piercing the corporate veil. You say, well, there has to be, the failure to observe formalities plus a legal wrong in some way. So that lends itself to the latter category where you say, well, someone's just created this group and they intentionally obscure who owns what. and, which then creates a legal wrong to the creditor. So I don't know if you want to press that more. It seemed that your solution was going to cover, the examples you gave, the two examples were both the inadvertent and the manipulative. And I don't know if you care more about the one rather than the other. And then my second comment for you is, anytime anybody says anything about limited liability, in the academy, and it's been a subject long debated, is you keep wondering, well, then how could it be gamed? How could any solution that you come up with be gamed? Because I think the longstanding criticisms of people who try to address issues in limited liability is, people say, well, they're just going to game it. You'll come up with something and then they'll find a way around it, because people just search for that limited liability. And so I ask you, is that a problem that you see as well? Would firms, incorporate, or there's certain jurisdictions that all go to the Cayman Islands where it'd be easy to do their formalities and what have you? That's maybe something you want to address. And then the final one, on that is, it's kind of one side of things. They've obscured, the corporate groups have obscured the situation. But on the other hand, the creditors haven't figured that out, and now again, are there certain classes of creditors, the trade creditors, the kind of dumb creditors who, we should try to protect them, but certainly the sophisticated ones that you feel, well, they've got Don Bernstein's firm, can't they figure things out and then demand protection and sue them if they don't do a good job? Okay, so that I offer as comments.
So, we had a bunch of questions that people wanted to jump in. Do you guys want to quickly respond to the comments that have already been given? And then we'll yeah. I've got Jim and, yeah.
Yeah, I think James kind of responded to his own solution to some degree by saying, yeah, right, the disabling strategy in bankruptcy, it just gets very complicated, right? Because there's so many people who have potential control in a bankruptcy case. So, but I think we can leave the rest of the time for comments and questions.
Since you were kind enough to address my paper with a very short time fuse, I appreciate that very much. I'll just comment, I'll make two comments. One is, you're right about the responsible people will just game it, right? But I think the answer to that is, it's just like warfare, right? There's the offense gets ahead, and then that doesn't mean you don't try to defense that offense and so forth. That just is an endless process in law of coming up with solutions to last year's problems, and then at least forcing people to develop something new and maybe marginally better as a result. It's an absolutely fair point, but that's my response to it. Something that is, to some extent, a response, but also really very appropriate, I think, for your paper, which is just terrific. And maybe some of our discussions in the last 24 hours, is that one of the purposes of bankruptcy, and indeed one of the purposes of corporate law, it seems to me, is providing institutional structure, right? If we want to get a bunch of capital together and try to go out and do something, we need a structure to organize the people who want to do that and the people who want to extend credit to that enterprise and so forth. And by the same token, bankruptcy provides institutional structure that I think is very important. And when we talk about, do we do this outside of bankruptcy or inside bankruptcy, of course we all know if we do it outside of bankruptcy, it's going to reflect what would happen if bankruptcy was filed. So bankruptcy has an influence on the process either way. I was struck by your comment about Cedro, which I think is a fascinating case, and I hope you'll tell me more about it because I'm just learning about it. But in that case, and when you talked about certain bondholders get all this money and others don't, but you said in Cedro, unlike the other two, the bondholders, I think you put it, got their act together or something like that.
Right.
And I think the answer is bankruptcy is supposed to provide the structure that enables a whole bunch of people to get organized to deal with defending their interests and making sure that all of the interests are properly represented. So I think all of us need to think about that institutional role of bankruptcy when we talk about, oh yeah, we're happy to just ratify whatever was done before bankruptcy, or indeed outside of bankruptcy. Anyway, so those are my
And I
comments.
think this tying back into one of James's comments is too, right? One of the differences in Seadrill may be the fact that they had to go shop, which they didn't have in the other two
Yeah, fair
cases,
enough.
so.
Okay, so I have Jim, Phil, Marty, Andrew, and Dan, and if any, and John. Okay, so Jim.
Okay, a couple of comments. Very interesting presentation. I want to advert back to Judge Gerber's pre-coffee break reference to the restructuring support agreement and the importance of the RSA. And I view that as a bridge between pre-bankruptcy or non-bankruptcy exercise of control rights and a post-bankruptcy, you assume it, perform it, and maybe live or die by it because it becomes a target for others who don't have those control rights to pursue claims that it's unfair, they were left out, and in terms of valuation, it may misallocate as among various creditor groups. I think that Seadrill, as I understand it, is an interesting example of efforts to set the table before the bankruptcy and then for the table to be upset after the bankruptcy by attacks on the RSA. So one of the post-petition control changes in bankruptcy that we haven't commented on yet, or at least I haven't heard it, is the role of the creditors committee as an estate fiduciary to question efforts by those who were in control to determine timing, milestones, allocations, distributions, and in fact, the committee comes in often with very little at stake other than to upset the apple cart and then to get something for their effort. I wanted to comment very briefly on Jay Westbrook's paper, which I haven't read, but I've heard him talk about this on any number of occasions. Last time was a couple of years ago in Tokyo when there was a Nortel panel. I think that the one bankruptcy term I didn't hear in Jay's presentation was substantive consolidation. And the devil in the proposal is that it would disregard separate corporate formalities and effectively scramble all the eggs and reallocate on the basis of one omelet. I question whether or not that's a good thing, but I'm simply saying that one of the reasons I question it is my own experience in a corporate group case when I was presiding over the Lehman Brothers case. And at the very beginning of the case, when the case was in change of control mode, immediate change of control mode for a sale of North American broker-dealer to Barclays, creditors complained mightily to make sure that consideration was properly allocated by affiliate to the extent that could be done, or at least all rights were reserved as to that issue. And then at the end of the case, there was a substantive consolidation dispute of enormous magnitude that was settled. The settlement involved a reallocation of value from operating companies to holding company. I'm simply saying that there is already some precedent that needs to be either explained away or respected.
Phil?
Yeah, so I had reactions to both sets of papers. I want to make 2 points, and mostly because I'd like to come back to them in the final session as food for thought. Let me start with the first paper. I think the real concern in cases like Seadrill, and there's plenty of others, is whether a particular subset of creditors within the same class, because they have a blocking position, are getting extra benefits, frankly, notwithstanding all of the protestations, in respect of their holding. And I have written letters I represent an ad hoc group, dear Board of Directors, I represent an ad hoc group of creditors that holds more than 2/3 of the notes in an issue. What is the message being delivered? I control the case, I can give you peace. And the two things you can offer the company in that circumstance and management, and this is the thing I think you need to look at and worry about. One is, what does management want? Let's assume it's a deeply insolvent case, so they're out of the money. One, releases. Bankruptcy plans, the same letter will say, oh, by the way, we have a zillion claims against management of all the following nature. What is the subtext? The subtext is, we can give you a release because we control the class. Two, the other thing management wants is it wants to remain and it wants an equity stake. What ends up getting negotiated in a lot of these cases is how much of the equity is left for management if management is going to remain. What is the MIP, Management Incentive Plan? And what really, I think, to the extent there's a subtext here to worry about is whether if my group has more than 2/3, I can, by offering management a release and a little bit extra of the equity, buy preferential treatment for my group over Don's minority group of the same bonds. That, I think, is the issue, and it's not clear to me what the answer is or whether there's a better process, but I think that's, frankly, the issue. Professor Westbrook, on yours, I think these are good questions. I sort of have a very different reaction than Nortel and Caesars. Caesars, whether true or untrue, is a case with allegations about a private equity firm basically engaging in a whole series of fraudulent transfers in order to take value for itself at a point in time when the enterprise was insolvent. Whether those allegations were true or not, those certainly, if true, are legitimate concerns. In a case like Nortel, I would suggest lots of large corporations, conglomerates, don't really honor all that much the corporate form. And frankly, let's just put this on the table. If insolvency never arises, it doesn't matter, because there's enough value to pay the creditors of every debtor. And what I think you'll often have management say, I'm not a corporate lawyer, but I've certainly heard this, is if we dot every I and cross every T, there's going to be enormous administrative expenses, and that will reduce value to equity. And so we cut a few corners on documenting everything, including figuring out whether this particular asset is part of Nortel Canada or Nortel US or Nortel Germany. And in 90% of the cases, or whatever percent don't become insolvent, it doesn't matter. I think before one demands a system that, for example, would require non-consolidated audited financials for every company within the conglomerate, one has to ask the question, is that going to impose a cost that exceeds the benefit to be derived in the instance of insolvency? Because if you did require, for example, in an extreme example, audited financials outside of bankruptcy for each and every affiliate, I suspect that would add material costs that would reduce equity value for shareholders. And so I don't know the answer to whether the cost would exceed the benefits, but I would worry about it.
Although, Chair, prerogative here, but the flip side is you're looking at that cost, the cost to respect the corporate form. You also need to be asking, what is the benefit to the shareholders of maintaining or of asserting a corporate form that you're not really respecting? In other words, the relevant question is the partitioning creating value? What is the cost of the partitioning, and what are the costs of non-partition? Yeah, that's Marty.
So I want to speak briefly about CGG without getting into anything that isn't public. I consider the Chapter 11 case and the Chapter 15 case no-brainers. the recognition of the safeguard proceeding in France, no objections, it was clearly proper. I wrote an opinion about it. I don't think anybody's questioned that. The Chapter 11 plan, look at the votes. It was 96+% for each class that voted. Okay? I start with the proposition that making sausage is not always pretty. But I think you need to look, I would suggest that you spend some time looking at what a sauvegarde proceeding in France is. It's a pre-bankruptcy. The company has to be solvent. I analogize it, and I ask questions about this during a hearing to try and understand it. The closest analogy I see is a scheme of arrangement proceeding. All that was done was restructuring balance sheet. Trade creditors were all paid in full. They're in the oil field services business, offshore. Unsustainable at the present time, given the price of oil. They had to do a balance sheet change. And that involved debt for equity, and yes, it's a complicated financial structure. In the sauvegarde proceeding in France, there was a mandatory judicial administrator who was appointed. She's really tough. She's very good, very experienced. She spent 6 months negotiating. There were no lockup agreements to start. She spent 6 months negotiating. Jim Peck, when he was still on the bench, was the mediator for me in ResCap. He spent months. Didn't quite get everybody on board, but, okay. So Helene Barbalou spent months, 6 months. Okay, it's common here, outside of bankruptcy, for ad hoc committees to have their fees paid while they're negotiating. I haven't heard people raise questions about that. Ted, you talk about free riders in your paper. There's a benefit to those who maybe aren't part of the ad hoc group who get the benefit of it. So I'm not, yes, I think you need to consider and think about the fees, okay? But the result in France, there was one group of holders in CGG who opposed, not here, they only opposed in France, okay? And the court overruled. I understand that last week the plan became effective, the safeguard plan became effective last week, okay? It was well over 90% per class voting in France. The process of making the sausage isn't always pretty. The goal, I've always thought, the goal of a Chapter 11 plan is a consensual plan that creditors will agree on. If you could get 96% of every voting class to agree, and the only objectors are those whose rights aren't being affected, sounds like a pretty good plan to me. So I think you ought to go back and look at the particulars of the safeguard plan, which I'm not an expert in, but I spent some time trying to learn it before I was willing to confirm a Chapter 11 plan or a 15 plan. But easy for me. There were no objections, and I thought it was appropriate. But, you know, let me stop there.
So I mean, Marty, you raised an important sort of point when you look at, is there an intermediate regime that we could be talking about? And it's going to be very important as on the international level, as you have schemes and safeguards, and now there's a big push in Europe towards protective pre-bankruptcy arrangements where the restructuring is purely a restructuring of the financial creditors, and whether that changes some of the things that Jay and Henry and I'm worried about. And the answer, my own sense of this is, I haven't decided whether I can stop worrying yet or not. But the fact that you've surfaced that, I think, is really important.
Just not necessarily specifically responding to CGG, but I think we have an added problem in the international cases too, where, as I understand it, in some of the cases, the parts of the case have been split across jurisdictional lines in a way that makes it impossible for any one judge to figure out what's going on, and also to make it so that basically you can get massive consent in one jurisdiction because basically everybody knows that the case is going to go through no matter what, so why not sign on and get the extra recovery you're going to get as well. And it also makes it impossible for anybody to stop the case. So, and I kind of alluded to, this may have been going on in CGG, I don't know, But in other cases, I've been told that it has happened that the lockup agreement is intentionally done under foreign law, because you know then that you can keep creditors from objecting in the U.S., because you can then sort of, you have an ability to enforce in a foreign jurisdiction on the lockup agreement, and so basically you can keep them from saying anything in the U.S., and so the U.S. bankruptcy judge will not be told, hey, we actually don't like this plan, but it was better than the alternative, something like that.
You don't always see at Vitro, right, where you can't always keep them quiet.
That's the case I wanted to raise. I mean, these cases bear a strong resemblance to Vitro, in which I found myself involved, and which is the case that was approved in Mexico and then brought to the U.S., and very unusually, the U.S. chose not to recognize the result. And it strikes me that maybe this is a different strategy now. We don't want to get Vitro'd, right? So what we'll do is have the case in two places at the same time, rather than getting it resolved in one place and then bringing that solution here. So, and I don't know to what extent that's the case in these three, but I was very much struck by that. And that was certainly a situation in which the hope of the plan proponents, it was a terrible plan, that was that by doing it in Mexico first, U.S. courts have been very friendly to Mexican bankruptcy judgments, have enforced them all over the place, and therefore the hope was to just get on that train and ride on through the station without stopping, and it didn't work in vitro. So, but I think the scheme of arrangement thing is an enormous mountain of cases that are going to be coming to the U.S., and I'm not sure that any of us have thought all that through as much as we should, although I'm constantly hearing some of my practitioner friends say, well, we've got to get rid of the Trust Indenture Act, and we've got to adopt systems so we can do the same thing, because otherwise we can't compete in the legal marketplace. And at that point, I start turning red, and then the conversation ends.
Let's not turn anyone red, though. Speak quickly, I might turn red. So, Oscar and Stephen, I really enjoyed the work there. I like boxes and grids and clear analytic prose and good factual dives in. I do have a question about what sort of things we might end up learning from it. So it might be good to figure out what the candidate answers your paper might generate are, and then look more carefully at what candidates are satisfied. So it might be that we think that bankruptcy creates special opportunities to increase the private benefits, and so you then might look at the cases and say, well, because of these blocking positions or whatever, maybe private benefit extraction is going to be higher than usual. Then you'd want some benchmark, and you'd say, well, these, Seadrill might have been paying crazy consulting fees already to equity or to whomever. That might be why they're bankrupt or something. And so, there you go. So getting some benchmark, if you can, to say, are we seeing larger extractions in certain bankruptcy contexts than you saw in a controlled solvent corporation? Secondly, you might ask, are there interesting, I guess, distributional questions to Professor Fanto's comment about who's getting whatever level of private benefits are. It might be a fixed level of private benefits, but it goes to new people now. That might offend bankruptcy policy, though. It's an interesting thing, as John pointed out, on your chart here, it seems like they all end up in the middle column, the controlling creditor group. Your three case studies are all in that column. The lesson might be there's a centripetal force in bankruptcy that creates controlling creditor groups when they're able to capture private benefits, and so this right column ends up it drops out, right? Maybe. And then thirdly, regardless of who and how much, there's the process of how people come to get their slice of the pie, and you might worry about whether these blocking positions or whatever create costs. Your label here of contested plan in the upper left-hand corner suggests that maybe searching private benefits out in some context leads to costly contestation, though it's not clear from the case that you described. One doesn't see evidence of the shareholders and the creditors engaging in costly contestation. The suggestion is they were able to find a pretty quick resolution to put themselves first. And so if there's real contestation, it's worth finding, and if there's not, then maybe you emphasize that it's not a contested plan, it's an unlikely bargain plan or something like that. Jay, if I may, I'm not an expert in the Caesars case. I'm not an expert. It's really unclear why I'm on this panel or at this talk. But it does seem to me that isn't it the case that the management in Caesars or in Nortel, they don't need a new reason to learn their lesson. The $2 billion of litigation in Nortel is lesson, and the potential victims in cases like Caesars or Nortel that your solution could help, those victims could be getting security interests to protect their interests even under status quo, right? I mean, asset partitioning theory is strongly associated with corporate law, but security interests are asset partitioning too, and they're stronger against management accidental or intentional diversion. And so, in fact, one might have the theory that the choice to not use security interest is precisely because they like the giving management the flexibility and lower administrative costs. That's a deal that the creditors have. So we'll take a little more risk of shuffling, but we, just make sure that the transfer pricing works out great for us, and we're lending against that surplus. So it might be interesting to say, it might be interesting to ask whether the menu of options already on the table allows creditors to get the protections you want, and if they do, why we want to create a different default rule or a different story rather than letting creditors bargain for what they want to get.
Yeah, one of the things that intrigues me about Nortel, and that I don't know the answer to, and I'm not sure anybody does, there was huge argument and litigation, and experts and so forth, over whether or not there was a differential between the cost of the bonds, the pricing of the bonds for the U.S. company and for the parent company, which would reflect that there was this extra guarantee in favor of the U.S. company. Whether or not anybody was thinking of it that way, who knows? In any event, there was at least a strong argument that the market didn't reflect that difference at all, that the guarantee was simply unimportant to the market. Well, that could be, if there are other such examples, that could be enormously important to anything I'm saying, or more importantly to the problem that we're talking about. If anybody has an insight into how that plays out, whether or not the market really does price those sorts of things. Yes, I'm buying bonds from the U.S. affiliate, and I therefore would be willing to pay more because there's a security. I would love to know more about that if anybody is aware of data that address that.
The last question, Dan. Oh, thank you. Okay.
I'm sorry if I jumped.
No. So this is also addressed to Jay. As a non-bankruptcy person, what struck me about your radical discussion is that the radical proposal you're making is this black-letter law that we teach in intro BizOrgs, namely, if the corporation doesn't treat its asset partitioning seriously, neither will the courts. And it's a little shocking to me, actually, to hear that in the Nortel circumstance, that there wasn't instantly consolidation. And it's a little puzzling to me why that isn't the answer. So the standard explanations for why limited liability is permitted in contract context all require full disclosure. The notion is that we collectively don't have a very clear reason to think that one set of assets ought to stand behind one particular set of obligations or not, right? That's something that's much better left to individual market decision-making. But individual market decision-making can only work if the market is working based on accurate information. Otherwise, all we're talking about is, if it's not fraud, it's at least borderline consumer deception, right? And as I'm hearing, the explanation that two people gave, Andrew gave it, and I think Philip also suggested, that the reason why the creditors might like this asset partitioning, even though they didn't know what was going on, was tax evasion or tax avoidance. Now, it's a little hard for me to understand why corporate law ought to be making it easier for companies to avoid taxes. Corporate law maybe doesn't see its role as promoting the rule of law, but it does seem to me that reducing the rule of law should not be a corporate law goal. And so I would start with a baseline rule that says, if the reason you're asset partitioning is in order to use transfer pricing to avoid the income tax in one country or another, maybe that's the taxing authority's problem and not the corporate law problem, but there's no reason why you should be allowed to do that in a way that violates fundamental corporate law norms. And the fundamental norm here ought to be, it ought to be the standard norm that we teach in first-year corporate law, which is if you want your corporation treated seriously, you need to treat it seriously. And if you act as if the entire organization is one firm, that's fine, that's your decision. But you shouldn't be allowed to take the inconsistent position that it's all one firm as long as things are doing well and all we're doing is cheating the government. But it's lots of separate firms when things go badly, and now we're talking about allocating among different creditors.
I don't think Nortel was, as I recall, it has been a while, really about tax evasion. I mean, what was going on there was you have intellectual property and intellectual property licenses. And so technically the IP license is owned by Nortel X, Nortel Germany. But it then lets every other Nortel company use the IP and doesn't require licensing fees. And it turns out that 90% of the revenue from the use of that IP is generated in the United States by Nortel US. So does that mean that when you sell the thing, 90% of the value of the assets or 90% of the proceeds should be attributable to Nortel US and the Nortel US creditors? I will say, without disclosing client confidences, lots and lots and lots of note holders in that case actually did buy and take positions with expectations and understandings of really who owned the assets and how it would be allocated. And I don't know a single note holder, no matter where they were in that case, who's happy today. And a lot of people's expectations were properly or improperly dashed. But what really was going on is, I think, when Nortel is solvent, the notion that we're going to have licensing agreements between different Nortel entities and require money on, to be transferred or bookkeeping entries, I think was just viewed as like, why go through that? It's just a pain in the neck, and so we're not going to do it because as long as we're solvent, none of this matters. And no one at Nortel was thinking about what happens if there comes a day we're insolvent.
Can I make a quick? Can I make a very quick comment, unrelated to what Phil just said completely, but related to what was said moments before he spoke? Has nothing to do with Nortel. The implication that corporate structuring carries with it some kind of intent, nefarious or otherwise. I believe that to a very large extent, corporate groups form haphazardly over time for reasons that have to do with acquisitions, the desire to move into a new field, the desire to move into new geographical areas, and that when we look at something like Nortel in the rearview mirror, we're not looking at something that necessarily reflects scrupulous corporate planning.
That's actually a great segue. I think to the extent there is any intent discernible in the corporate groups, the only intent that's robustly generalizable is tax avoidance. You read this, law and econ stuff, like, well, of course, it's partitioning, and so they have these corporate groups so they can more efficiently monitor the client. Hogwash. It's all path-dependent acquisition stuff, maybe tax avoidance. There's neither rhyme nor reason to it. And I think Jay's right to call bullshit and say, what we should do is cleanse substantive consolidation of its pejorative label and say, let's start with a presumption of substantive consolidation. We did it in Nortel. Some note holders might be disappointed, some might not be. If they're going to be disappointed, then when they monitor, let's use our, right, when they monitor them for their notes, they can insist on those annual meetings for the corporations with a separate entity that they are expecting to get their recovery from. And if they're just fine to let things wash around in the general thing, then when the dust settles, there should be a consolidation and you should share the assets ratably and equally amongst everyone. On your guys' project, I think Andrew, right, there might be some collapsing, and so you might actually just go down to one big mega cell, which is just honk and control by the creditor in bankruptcy, and that what you're finding is interesting there too, and particularly that the one where it seems like that's evaporating, you're seeing the protestations on the plan, which is nice evidence showing that when the control is not as robust, then people stand up and fight the plan and stand on their rights. On Dennis's comment, about the potential futility of disclosure in bankruptcy because the liquidity will dry up, I'm not convinced, or let me put it this way. Liquidity does not appear to have dried up outside bankruptcy where people have to file these disclosure forms. And so I think it's at least an open question to see whether it would have a critical chilling effect in the bankruptcy regime as well. I'm going to table my comments on John's thing because I think that's going to be a good conclusion thing about JEVIC. How much of this is basically playing games with our purported adherence to equality and the hierarchy waterfall? And so I'm going to table that.
I think the right answer to that is, that's a really good question, but by now people are getting hungry, and I don't want to stand in the way of lunch.